This chapter comes from Phillip, Lipton and Abe Herzberg's Understanding Company Law. It was published in 2008 and it's the 14th edition. Chapter 1, Regulatory Framework. What is a company? A company is an artificial entity recognised by the law as a legal person with its own rights and liabilities. The terms company and corporation are often interchangeable. However, the Corporations Act 2001 regards a company or its predecessors registered under the Act as one type of corporation. A corporation also includes other artificial legal entities, such as trade unions and incorporated associations, as well as entities formed in other countries. A company is a separate entity distinct from its shareholders, its directors who control its management, and its officers and employees. The fact that a company is regarded as an entity separate from the people behind it means that the company may own property, enter into contracts, and sue and be sued in its own name. The separate legal entity concept also means that a company has a potentially unlimited lifespan. Its directors and shareholders may change, but this does not affect the company's existence as a legal person. Even though a company is an artificial entity, it has the same legal capacity and powers as a human being. It is therefore able to engage in any business or activity and may acquire and exercise rights in the same way as an individual. Limited liability is an important characteristic of companies and is often one of the main reasons why people choose to form a company to conduct their businesses. Limited liability means that shareholders are not personally liable for their company's debts. The shareholder's liability is limited to paying the issue price of the shares that they own. The implications of a company being a separate legal entity and limited liability are discussed below. That chapter also contains a comparison of a company with a partnership and a trust, the other common forms of business organisations. Transferability of shares is another significant characteristic that distinguishes a company from a partnership. As a general rule, shareholders are able to transfer or sell their shares free of any restrictions, and free transferability of shares is a requirement for listing on a stock exchange. Shareholders of listed public companies who wish to sell their shares do not need to obtain approval from other shareholders or the company's directors. Free transferability of shares facilitates stock exchange share trading. Most closely held companies with few shareholders restrict the transfer of their shares by provisions in their constitutions which require approval of the directors before shares can be transferred. The proprietary company replaceable rule is an example of such a provision. There are three main sources of rules that regulate companies. First, legislation, particularly the Corporations Act of 2001, which applies throughout Australia. Also important is the Australian Securities and Investment Commission Act of 2001, which established the Australian Securities and Investments Commission, also known as ASIC, as the main governmental authority responsible for administering the Corporations Act and enforcing its compliance. Second, case law, particularly those laws that establish contractual and fiduciary principles. And third, the constitution of each company, which sets out the rules that regulate their internal management. Company constitutions are discussed below. Companies are the most popular form of business organisation. There are over 1.5 million companies registered in Australia, and they vary greatly in the size of their businesses and their number of shareholders. The overwhelming majority of companies operate small business enterprises and are typically controlled by an individual person or a family. Some companies, particularly those that operate large businesses, frequently organise their affairs in a corporate group structure with a holding company that controls one or more subsidiary companies within an economic entity. The separate entity concept, as well as limited liability, have interesting implications for corporate groups. This is discussed further below. Company formation, also referred to as registration or incorporation, is a relatively simple process that involves filing an application for registration with ASIC and paying the prescribed fee. Once ASIC registered the company, it comes into existence as a legal entity and can operate anywhere in Australia. The procedures for registering a company are further discussed below. The Corporations Act makes a formal distinction between ownership and control of companies. Companies are required to have shareholders, also called members, who, in a non-legal sense, are regarded as the owners of the company. The shareholders contribute capital by paying the issue price on their shares and may receive dividends if the company generates profits. The Corporations Act and company constitutions give shareholders significant rights. For example, they have the right to receive the company's audited financial reports, and in the case of public companies, the right to attend, speak, and vote at the company's annual general meetings. Financial reporting and auditors are discussed in chapters 15 and 16 below. Shareholders' meetings are discussed in chapter 14. Every company must also have directors who are collectively referred to as a board. Company constitutions usually give directors the exclusive power to control management of the company's business. Because directors control the management of the company, they are subject to strict fiduciary and statutory duties. For example, directors are required to exercise their powers in the best interests of the company and its shareholders. Directors' fiduciary and statutory duties are discussed in Chapter 13. As discussed below, the Corporations Act draws a distinction between public and proprietary companies. A company must be one or the other. Proprietary companies are more prevalent than public companies, and their regulation is designed to suit the needs of companies with small numbers of shareholders. One-person proprietary companies are permitted. Proprietary companies are divided into two subcategories, small and large proprietary companies. The distinction is based on the scale of the proprietary company's business. Most proprietary companies are small proprietary companies and are subject to minimum financial disclosure requirements. The legislation imposes more onerous obligations and greater public transparency on public companies because they are permitted to raise capital from the public and usually operate large-scale businesses with large numbers of shareholders. The largest public companies choose to list their shares on the Australian Securities Exchange, also known as ASX, which operates the main Australian stock market in which shares of listed companies can be easily bought and sold. There are more than 2,000 companies whose shares are listed on the ASX. Listed public companies must comply with detailed disclosure obligations imposed by the ASX listing rules as well as the Corporations Act. The ASX listing rules also provide greater shareholder protection mechanisms than the Corporations Act. Despite the more onerous regulation imposed on listed companies, there are significant advantages to being listed for both listed companies and their shareholders. An active stock market enables investors to easily trade listed shares, and as a result, listed companies have the ability to raise very large amounts of capital. History of company law. Earliest companies. From medieval times, there has been a need for the creation of incorporated bodies with characteristics of legal personality. The earliest such bodies in England were monasteries and local government boroughs. They required that ownership of property be conferred on a legal entity separate from individuals, and that this legal entity continued to exist beyond the lifespan of individuals. Another early type of organisation was the guild that served the functions of trade union, club, and benevolent society. The guilds required incorporation as a method of excluding outsiders from their particular trade. These medieval organisations were incorporated by royal charter and were the earliest corporations. The needs of commerce in enabling individuals to pool together their resources were recognised by law in the development of partnerships whereby each partner was an agent of the other partners with unlimited liability. Commercial companies were formed to undertake businesses which required pooled investment from large numbers of shareholders. In England, most of these companies were involved in overseas trade and development of infrastructure such as canals, railways, roads, and water supplies. These businesses were often risky and required large amounts of capital to be invested, usually long before they generated revenue and profits, and were therefore unsuited to family businesses or partnerships. From early times, business enterprises were created either by Act of Parliament or Royal Charter, or were formed by adapting the partnership form so that they were suited to pooled investment. Incorporation by conferral of a charter enabled a separate legal entity, usually described as a corporation, to come into existence. Such corporations were recognised by the law as distinct legal persons, separate from their shareholders, and the shareholders usually had their liability limited to the extent of their investment. The business of the corporation was entrusted to a board of directors, and its capital was divided into stock or shares. Incorporation by these means was often accompanied by monopolistic rights, such as exclusive rights to trade in a certain area, and therefore a charter was a valuable right. The procedure to obtain a charter of incorporation was generally expensive, and so only suited to large enterprises and often required strong political influence. By the early 18th century, a large number of companies were privately formed without direct legal recognition. These were partnerships which operated under a deed of settlement, which provided for the division of the enterprise's capital into freely transferable stock and the appointment of managers or directors who controlled the company's business activities in similar ways to chartered corporations. These companies were known as joint stock companies. The Bubble Act was passed in 1720 to prohibit the formation of joint stock companies so that only companies incorporated by charter could be formed. This legislation was a response to excessive speculation, which culminated in the bursting of the South Seas Company bubble. It also represented an attempt by chartered companies to remove competition from joint stock companies for investment capital. Although the Bubble Act remained on the statute books for more than a century, it was rarely used and did little to inhibit the formation of joint stock companies during the British Industrial Revolution, especially in the areas of canal and railway construction when pooled investment demand increased considerably. The regulation of joint stock companies presented a number of practical difficulties. The law considered them as a form of partnership with large numbers of members. It was therefore difficult for these companies to sue and be sued, because under partnership law, all partners once had to be parties to any litigation. This was practically impossible where a company had large numbers of shareholders and the membership constantly changed as its shares were traded. Partnership law also presented difficulties where a partner sought to assign a partnership interest. This required the unanimous agreement of all partners. The deeds of settlement of some joint stock companies provided for a type of limited liability of shareholders by the inclusion of a provision which required company contracts to contain terms which restricted the right of outside parties to access the assets of shareholders in satisfaction of company debts. This modified the general partnership rule that partners have unlimited liability. However, this result was achieved in a cumbersome manner, and in many cases, the effectiveness of this means of limiting liability was uncertain. Early companies legislation. In order to bring greater certainty to the operation of companies and encourage their formation, a series of acts were passed in England between 1844 and 1856, which remain the foundation of modern Australian company law. These acts sought to make a clear distinction between companies and partnerships by providing that all undertakings of more than 20 persons were required to incorporate as companies. It was open for any enterprise which met the statutory requirements to incorporate and be registered as a company. One early requirement was that there be a minimum of 7 shareholders. Limited liability was finally permitted after legislation was passed in 1855 and 1856. The various statutes dealing with companies were consolidated in the English Companies Act 1862. This legislation established all registered companies as separate legal entities distinct from their shareholders. By the late 19th century, many family businesses and partnerships used the companies legislation mainly to gain advantage of limited liability. These businesses were usually conducted by an individual or a small number of partners with family members, friends or employees making up the required minimum number of shareholders. Until Solomon's case, discussed below, it was unclear to what extent the separate legal entity principle extended to what were in reality one-person companies. The Australian colonies very soon after passed legislation closely modelled on the 1862 English Act. In Victoria, the no liability company was introduced for mining companies in 1871 in order to encourage investment in the mining industry. This type of company is described below. Victoria also introduced a number of investor protection reforms in 1896, when a distinction was made between public and proprietary companies with greater financial disclosure requirements imposed on public companies. Proprietary companies were seen to be most suited to small businesses which had relatively few members and which operated in a similar way to partnerships. Such companies were not required to have their financial affairs audited, nor were they required to publish their financial statements. Case law and legislation. The result of the history and development of company law, both in England and Australia, has been the interaction and interdependence of case and statute law. It is necessary for the study of company law to understand the interrelationship between cases and the Corporations Act, for each presumes the existence of the other. Over a long period of time, the courts have been asked to interpret and define many aspects of the legislation. In turn, the parliaments have amended the legislation over the years, assuming the existence of common law principles which evolved from the cases. Thus, the Corporations Act does not purport to be a comprehensive code covering all aspects of company law. Rather, the sections of the Corporations Act must be read in conjunction with case law, which gives the legislation greater meaning. This situation is to be contrasted with the law of contract, for example, where the legal principles largely come from cases through the doctrine of precedent with relatively little statute law. Development of Australian company law. Constitutional position. During the first half of the 20th century, Australian company law was characterised by a lack of uniformity from state to state, because the Commonwealth Parliament was not given a clear power by the Australian Constitution to make laws with respect to all companies. The closest such power is Section 51 of the Constitution, which gives the Commonwealth the power to make laws with respect to foreign corporations and trading and financial corporations formed within the limits of the Commonwealth. In the early years of the 20th century, the High Court adopted a narrow interpretation of the power in Section 51, so as to deny the Commonwealth the power to make laws with respect to the formation of companies. Huddart, Parker and Co. Proprietary Limited v. Moorhead in 1909 is a case. This conclusion was based on the strict interpretation of the word formed, meaning already in existence. It was also regarded as questionable whether mining, investment and charitable companies were trading or financial corporations. The result of this interpretation was that the Commonwealth had limited jurisdiction under the Constitution to make laws with respect to the incorporation and regulation of companies. This was historically largely a state matter. This approach to the interpretation of Section 51 was followed by the High Court in New South Wales versus Commonwealth in 1989. This case concerned a challenge by several states to the constitutional validity of certain sections of the Commonwealth Corporations Act of 1989, which provided, among other things, for the incorporation of trading and financial corporations. The High Court held that a Section 51 did not empower the Commonwealth to make laws with respect to the formation of trading and financial corporations, and consequently, provisions that related to company formation were invalid. The basis of the majority judgment focused on the phrase "formed within the limits of the Commonwealth" in Section 51. The Huddart-Parker case was followed to interpret this phase as referring to corporations that have already been created in Australia and excludes the process of formation itself. In order to overcome the difficulties arising from these constitutional limitations, from the 1960s onwards, the Commonwealth and states entered into various agreements aimed at achieving greater uniformity in the regulation of companies throughout Australia. Uniform Companies Acts. The Uniform Companies Acts of 1961 largely achieved the aim of attaining uniform legislation throughout Australia. Each Australian state enacted essentially identical legislation. It was then possible to speak of a particular section, and generally this was identical in the Companies Acts of each state. However, over time, amendments were adopted in some states but not others, so that differences between states began to reappear. As well as lack of uniformity in the respective Companies Acts, it was inconvenient for a company operating and raising funds throughout Australia to have to comply with all the applicable Companies Acts. For example, a company incorporated in one state was regarded as a foreign company in the other states, and therefore had to comply with a series of laws and regulations applicable to such entities. Also, if a company wanted to raise funds throughout Australia, it had to register a prospectus in each state. A further matter of concern related to the lack of adequate regulation and supervision of the stock exchanges. There was no single regulator or stock market operator with power to supervise the various state-based stock exchanges or interstate share trading. As a result of a severe stock market crash in the early 1970s, with associated allegations of improper practices, a Senate Select Committee, the Ray Committee, was set up to inquire into the securities industry. The main recommendation of the Ray Committee was that a national commission be established to regulate and oversee the activities of all the securities markets throughout Australia, thereby recognising the reality that the securities industry in Australia operated on a national basis. Cooperative Scheme. The cooperative scheme was developed in the 1980s to establish both uniform legislation and uniform government administration of the law. This was achieved in 1981 when the Commonwealth passed legislation that applied only in the Australian Capital Territory, and each state passed legislation applying the Commonwealth legislation as its own law. The legislative package of the Commonwealth Acts and State Application Acts was referred to as a code. For example, in Victoria, the companies legislation was referred to as the Companies (Victoria) Code. An important feature of the cooperative scheme was that it established the National Companies and Securities Commission, NCSC, a predecessor of ASIC, with the responsibility of formulating policy, administering company law, and regulating the securities and futures industry. While the NCSC was a Commonwealth government authority, it was required to delegate many of its significant responsibilities, such as the incorporation of companies and filing of documents, to the various state government authorities called Corporate Affairs Commissions. It was widely acknowledged that the cooperative scheme was a considerable improvement on previous legislative structures. It produced greater administrative efficiency by introducing the concept of one-stop shopping. This concept meant that a company carrying on business in more than one state or territory could lodge its various documents, such as annual returns or prospectuses, with the Corporate Affairs Commission in its home state without the need to file duplicates elsewhere. During the late 1980s, the cooperative scheme came under increasing criticism. This was partly related to its compromised nature, which sought to balance national and state interests, and partly due to the rapid changes taking place in the corporate and global financial environment. This increased the importance of collaboration between national regulatory bodies and resulted in more sophisticated corporate and market dealings. The cooperative scheme structure also diffused political responsibility through the Ministerial Council for Corporations and Securities, MINCO, so that no single parliament or government minister was responsible for the legislation. Amendments to the legislation required the approval of MINCO. Because MINCO comprised ministers representing each state and the Commonwealth, it was unwieldy from the point of view of reforming the law to take account of contemporary practices. This resulted in a tendency to produce lowest common denominator amendments. The relationship between the NCSC and the State Corporate Affairs Commissions also resulted in administrative inefficiency. Each of the Corporate Affairs Commissions adopted its own interpretations of the law and rulings. The NCSC was not empowered to give directions to the State Corporate Affairs Commissions on administrative procedures or deployment of resources. This was critical because the NCSC itself operated on a very small budget. Corporations Law Scheme, the attempted Commonwealth takeover. The deficiencies of the cooperative scheme led the Commonwealth to attempt to take over sole control of companies and securities regulation from the states. The Commonwealth passed the Corporations Act 1989, which largely amalgamated the provisions previously contained in the various separate codes. It also enacted the Australian Securities Commission Act 1989, which established the Australian Securities Commission, ASC, to replace both the NCSC and the respective state corporate affairs commissions. The Commonwealth's attempted takeover provoked intense political controversy. Several states were hostile to it and challenged the constitutional validity of the new Corporations Act 1989 in the High Court. Some states were concerned that as a consequence of the replacement of their corporate affairs commissions by the ASC, they would lose control over local companies, as well as their ability to generate revenue from fees levied on companies. 1989 High Court Challenge. The legislative package was passed in September 1989, but several states brought a High Court action against the Commonwealth, alleging that the 1989 legislation was unconstitutional. That's the case New South Wales versus Commonwealth, 1989. In this box here it says the only issue to be considered in this case was whether or not the provisions in the Corporations Act of 1989 concerning company incorporation were constitutionally valid. The High Court held that the Commonwealth did not have the power, under a Section 51 of the Constitution, to pass laws providing for the incorporation of trading and financial corporations, and therefore the Commonwealth did not have the power to completely take over corporate regulation in Australia. Key features of the scheme. As a result of the decision in New South Wales versus Commonwealth 1989, The Commonwealth needed the cooperation of the states in order to arrive at a structure that, on the one hand, addressed the deficiencies of the cooperative scheme and, on the other, satisfied the respective governments. After the High Court case, the Commonwealth and states negotiated a new arrangement, the Corporations Agreement, setting out the key features of the Corporations Law Scheme. The Corporations Law Scheme established a legislative framework of Commonwealth legislation applied as state law. This was similar to the previous cooperative scheme. The Commonwealth amended the Corporations Act of 1989 so that it applied only in the Australian Capital Territory. The last section of the amended 1989 Act then stated, "The Corporations Law is as follows. Technically, the Corporations Law, which comprised over 2,000 sections and 3 schedules, was contained in one section of the Corporations Act 1989. Each of the states and the Northern Territory passed their own legislation, which applied the Commonwealth's Corporations Law as their own law." The Corporations Law commenced operation on 1st of January 1991. Each of the 8 corporations laws, while technically legislation of a particular state or territory, had the characteristics of and were treated for all practical purposes as if they were a commonwealth rather than state law. The essential difference between the cooperative scheme and the Corporations Law Scheme was the increased power and control over corporate regulation given to the Commonwealth. The ASC, with regional offices in each capital city, was established as the sole government authority. It replaced both the NCSC and the respective state and territory corporate affairs commissions. The ASC was accountable only to the Commonwealth Parliament, with the Commonwealth Attorney-General as the responsible minister. The ASC was renamed the Australian Securities and Investments Commission, ASIC, from July 1998, with the Commonwealth Treasurer as the responsible minister. The role and functions of ASIC are further discussed below and in Chapter 21. To ensure uniformity of corporate regulation, the Corporations Law Scheme provided that Commonwealth bodies such as the ASC, the Commonwealth Director of Public Prosecutions, the DPP, and the Australian Federal Police were the authorities responsible for investigation and prosecution of criminal offences under the legislation throughout Australia. Apart from establishing the Corporations Law, a complex legal framework to federalise the Corporations Law Scheme was set up. For example, even though each of the 8 corporations laws was technically a state or territory law, the scheme provided that the Corporations Law was to be administered and enforced on a national basis in the same way as if it were a law of the Commonwealth. Commonwealth administrative laws applied to the respective corporations laws, with the result that Commonwealth administrative bodies such as the Commonwealth Administrative Appeals Tribunal and the Commonwealth Ombudsman were given jurisdiction to the exclusion of their state equivalents. The various Corporations Acts also federalised criminal law, so that corporations law offences were treated as Commonwealth offences, even though the Corporations Law was technically the law of a state. Further, criminal investigations and prosecutions of corporations law offences were carried out by federal authorities such as ASIC and the Commonwealth Director of Public Prosecutions. Prior to the High Court's decision in Re Wackim 1999, discussed below, the Federal Court of Australia was the main court for hearing corporations law cases, even though they were based on the corporations law of a particular state or territory. This was achieved by the cross-vesting provisions of the State and Commonwealth Corporations Acts. Under this system, the Federal Court, the Family Court, and each state and territory Supreme Court had jurisdiction to decide corporations law cases irrespective of which state or territory the dispute arose in. The cross-vesting system also enabled one court to transfer cases to another court in appropriate situations. Constitutional crisis. The constitutional validity of the federalised nature of the corporations law scheme was thrown into doubt in a number of High Court cases, such as Re Wackim, 1999, Bond and R, 2000, and R and Hughes in 2000. The constitutional problems highlighted by these cases focused on the power of Commonwealth authorities to deal with issues arising under the corporations laws of the various states and the Northern Territory. In Re Wackim, 1999, the High Court held that the cross-vesting provisions were unconstitutional and that the Federal Court did not have the power to decide matters that were exclusively within the jurisdiction of the states. Since the corporations law was legally state legislation, this decision meant the Federal Court could not hear or decide corporations law cases. In Bond and R in 2000, the High Court held that while the Commonwealth DPP had the power to initiate and institute prosecutions, for constitutional reasons it did not have the power to appeal against sentences. The powers of the Commonwealth DPP were also the main issue in R and Hughes, also of 2000. In that case, the High Court recognised that it was only the peculiar circumstances of the case that prevented a successful constitutional challenge to the Commonwealth DPP's powers and called for prompt reform of the corporations law scheme. The decision in R and Hughes of 2000 also caused significant concern about the constitutionality of other aspects of the corporations law scheme. The High Court made it clear in that a Commonwealth body that undertook a function under state law involving the exercise of a duty had constitutional powers in relation to state legislation only if the Constitution gave the Commonwealth Parliament power in relation to the matter. This raised the question of whether ASIC, the main regulator of the corporations law scheme and a Commonwealth authority, had the power to register companies. This was a major practical issue, as ASIC had registered over 600,000 companies between 1991 and 2000. As discussed above, the High Court held in New South Wales v Commonwealth in 1989 that the Constitution did not give the Commonwealth the power to make laws dealing with the formation of companies. Clearly, early resolution of the constitutional crisis was necessary. Corporations Act 2001. In 2000, the states and the Northern Territory agreed in principle to resolve the constitutional crisis by referring to the Commonwealth the substance of the corporations law scheme together with the powers of Commonwealth authorities to carry out the scheme. Section 51 of the Constitution gives the Commonwealth this power in relation to any matter referred to it by the states. There was also agreement in principle for the states to refer to the Commonwealth the power to amend the legislation. The Commonwealth and the states also agreed that the referral would have a sunset clause to allow a state to terminate it after 5 years. As a result of the enactment of the referral legislation by the states, the Commonwealth passed the Corporations Act 2001 and the Australian Securities and Investments Commission Act 2001. That's also known as the ASIC Act. The Corporations Act 2001 replaced the previous Corporations Act of 1989, as well as the 8 corporations laws of the various states and territories. The ASIC Act 2001 is discussed below. The Corporations Act of 2001 became operative on 1st of July 2001 and now applies Australia-wide. If one or more states terminate their reference, the Corporations Act will still apply in the remaining referring states. The Corporations Act is administered and enforced on a national basis by Commonwealth bodies such as ASIC. In addition, existing Commonwealth legislation such as the Crimes Act of 1914, the Criminal Code Act of 1995, the Director of Public Prosecutions Act of 1983, and the Acts Interpretation Act of 1901 apply to the exclusion of equivalent state legislation. Part 9.6a of the Corporations Act reinstates the jurisdiction of the Federal Court and the integrating cross-vesting provisions in relation to civil matters and effectively overrules the decision of the High Court in re Wackim of 1999. The rules governing the interpretation of the various provisions of the Corporations Act are set out in the Acts Interpretations Act of 1901. For example, sections 15AA and 15AB of the Acts Interpretations Act directs the courts, when interpreting a provision of the Corporations Act, to prefer a construction that would promote the purpose or object underlying the Act. When the meaning of a provision is ambiguous or obscure, the courts are permitted to make use of extrinsic material, such as an explanatory memorandum relating to the legislation, a report of a law reform agency, or a report of a parliamentary committee. There have been numerous instances where the courts of the various states have adopted conflicting interpretations of the previous corporations legislation. However, in ASC and Marlborough Gold Mines Limited in 1993, the High Court was of the opinion that this lack of uniformity in the interpretation of the legislation was undesirable. In their joint judgment, Mason C.J., Brennan, Dawson, Toohey and Gaudron J.J. stated, uniformity of decision in the interpretation of uniform national legislation, such as the Corporations Act, is a sufficiently important consideration to require that an intermediate appellate court, and all the more so a single judge, should not depart from an interpretation placed on such legislation by another Australian intermediate appellate court, unless convinced that that interpretation is plainly wrong.